Welcome to Legal on Demand, powered by Maguire Legal. Conversations on law, business, and the decisions that matter. I'm Eda, and in this episode, I'm joined by a principal of Maguire Legal, Paul Maguire. Welcome, Paul.
Thanks, Eda.
In this episode, we're talking about pre employment checks and why they've become a critical legal and governance issue for employers. Recruitment is often treated as a commercial decision, but many of the highest risk employment disputes actually begin before the employee's first day.
That's right. When employers move quickly to secure talent without asking the right questions, they can potentially and unintentionally incur unwanted legal obligations for the business, such as restraint of trade issues, confidentiality risks, reputational damage, and liability for lost profits.
Stay with us as we unpack what employers should be checking before hiring, the questions to ask, and the risks of getting it wrong.
Eda, can you tell us why pre-employment checks matter?
Employers are not liable simply for hiring someone, but they may face legal exposure if they knowingly induce, assist, or allow an employee to breach enforceable obligations to a former employer, including restraints of trade or confidentiality duties.
To add to that, the federal court has consistently confirmed that post-employment restraints and confidentiality obligations can be enforced by injunctions to protect legitimate business interests. That means a new employer can suddenly face urgent legal proceedings shortly after a hire starts. In many cases, the new employer is joined in the legal action taken against the new employee.
A new employee failing to disclose or misrepresenting post employment obligations before accepting an offer of employment may also be grounds for dismissal. The Fair Work Commission doesn't regulate recruitment itself, but issues arise where inaccurate or misleading information later leads to dismissal. The Commission will then look at whether the misrepresentation was serious, whether it was material to the role, and whether the employer took reasonable steps, including verifying the information.
Yes, that is correct. Where employment is terminated because information is not disclosed during recruitment or otherwise misleading, Fair Work Commission will examine whether that issue constituted a valid reason and whether the employer's response was fair and proportionate. Employers can end up with legal action against them by the ex-employer, limitations imposed on the new employee, or face an unfair dismissal if you terminate the person's employment. Either way, it's not a good result. Timing and transparency is critical in these types of checks. They should occur before the employment contract is finalised, and offers should be conditional on the candidate confirming they can perform the role without breaching any existing obligations.
If the issue only emerges after the employee has commenced, the employer may need to change duties, delay key responsibilities, or even terminate employment, and potentially manage the risk of an unfair dismissal claim under the Fair Work Act 2009. So, Paul, what should employers be asking potential candidates?
At a minimum, employers should ask whether the candidate is subject to any post-employment restraints, such as non-compete clauses, non-solicitation, or non-dealing obligations. They should also confirm whether the candidate holds any confidential information, intellectual property, or client material from the previous employer, and whether there are any ongoing disputes or investigations.
Does this differ from senior or high risk positions and lower level candidates?
Yes, it does. The level of checking should always be proportionate to the level of risk associated with the role. For senior or let's call them high risk positions, particularly roles involving client relationships, access to confidential information, strategic decision making, or movement from a competitor, employers should take a more detailed approach. That may include asking the candidate to provide a copy of any relevant restraint clause from their previous employment and obtaining a clear written confirmation that they are able to perform the new role without breaching any post-employment obligations. In those situations, it's also important to understand the practical scope of any restraint. For example, the duration of that restraint, geographical limits of the restraint, and whether the role you're offering could potentially conflict with those restrictions. Of course, for more junior or lower risk roles, the level of inquiry can be more streamlined. A standard declaration confirming that the candidate is not subject to any obligations that will prevent them from performing the role is often sufficient. The key principle is transparency and, as I said earlier, proportionality. The greater the access to clients, confidential information, or competitive advantage, the greater the need for more detailed pre-employment checks.
And from a risk management perspective, documenting those inquiries is important. If a dispute later arises with a former employer, being able to demonstrate that reasonable steps were taken at the recruitment stage can make a significant difference to the organization's position. When we look at case law examples of restraint and confidentiality, the federal court has consistently enforced restraints where an employee joins a competitor and there is a real risk of client solicitation or misuse of confidential information. In some cases, the court has granted urgent injunctions preventing the employee from working for the restraint period.
From the employer's perspective, that creates immediate operational disruption and costs. The business may have hired someone who cannot perform the role they were recruited for.
Similarly, courts have taken a strong approach where employees bring client lists, pricing data, or even strategic material from a previous employer, even if the new employer didn't ask for it. Allowing that information to be used can expose the business to legal action and reputational damage.
Yes, that's why onboarding should make clear that the employee must not bring or use confidential information from former employers.
As you alluded to in the introduction, in many situations, the risk goes even further. Under Section 183 of the Corporations Act 2001, a current or former director or other officer or employee of a corporation must not improperly use the information obtained through their position to gain an advantage for themselves or someone else, or to cause detriment to the former employer.
And where a new employer knowingly benefits from that information, the former employer may seek remedies in the federal court, including injunctions, compensation, and in some instances, orders for the delivery up or destruction of information.
From a practical perspective, this is where the risk becomes operational as well as legal.
Exactly. If the employee's knowledge, strategy, pricing insight, or client intelligence has been built using confidential information from the former employer, the court may restrict how that knowledge can be used or prevent the employee from performing key parts of the role altogether. In some instances, the organization finds that the very expertise they hired the employee for cannot be used without creating legal risk. That can make the employment relationship commercially untenable.
And if the employer is already involved in litigation at that point, they're managing legal costs, business disruption, and the potential loss of a senior hire all at the same time.
Which is why, for senior hires moving from competitors, understanding the source and nature of the candidate's knowledge isn't just a contractual issue, it's a governance and litigation risk under both restraint law and the Corporations Act.
We've talked about what employers should be asking and how the level of checking should match the level of risk. But the real question for many organizations is what happens if those questions aren't asked, or if issues only come to light after the employee has already started.
When employers don't ask the right questions, the consequences extend beyond legal exposure. There is operational risk if the employee cannot perform the role, commercial risk if a senior hire leaves shortly after starting, and reputational risk if disputes arise with a competitor or regulator.
From a governance perspective, pre employment checks are about preventing foreseeable problems rather than managing disputes after they arise.
In competitive industries where employees move between organisations frequently, restraint and confidentiality disputes are becoming more common. Businesses that implement a structured and documented recruitment process are far better positioned to manage that risk.
The key takeaway is that pre employment checks are not an administrative step. They are a legal risk control that protects the organisation before the employment relationship begins.
Ask the right questions early, verify critical information, and document the process so you can demonstrate that reasonable steps were taken.
If you'd like assistance reviewing your recruitment processes or managing pre employment risks, you can contact us via our website at maguirelegal.com.au.
Thanks for joining us on Legal on Demand, Practical Law, Real Decisions on Demand.